Good evening, this is John Milburn for Laws 12060 Trusts. We're into week 11, 2017, and tonight we're dealing with termination and variation of trusts. Last week we dealt with trusts in commercial practice. This week we're dealing with the issues of variation and termination, but there is one topic that I would like to have touched on last week. I didn't have time, and it's to do with retention of title or remalpa clauses. Now, are we familiar with that topic? Because I'd like you to listen carefully. We are? Good, good. All right, so why on earth are we talking about remalpa clauses in the context of trusts? Well, the fact is that sometimes there's a crossover, and we saw that right at the start of the course when we were talking about trust and agency, trust and contract, and very often trust and succession law. So in the assignment that people have just completed, we had a lot of different answers about how we could go about dealing with the issue of trusts, and sometimes people were touching onto other areas, which is fine. I like if we think laterally. So retention of title clause, remalpa clauses, and we know that they're contractual clauses that are contained in contracts where there is a supply of goods in circumstances where the seller wants to retain some sort of interest in that property so that they're a better chance of being paid and not being left as an unsecured creditor in circumstances where the buyer goes into default. So it's a very common clause to include, and it all comes from the remalpa case which was Aluminium Industry, Vassan against Remalpa Aluminium, 1976 to All England 552. So 1976 to All ER 552. Okay, so we know what it is, and it's essentially a form of security, but it can either be a charge, which is secured, or it can be a trust. Two different ways of looking at it. And if you look at the Personal Property Securities Act, Commonwealth, 2009, you'll see that it treats retention of title clauses essentially as a secured loan, and it has its own way of prescribing enforcement for the security. Originally, remalpa clauses were trust law based. So the PPSA 2009 to some degree underpins that trust law by creating a situation where it's a secured loan. But there are some exceptions to that legislation. It excludes a transfer where the transferee, the purchaser if you like, holds the monetary obligation on trust for the transferor. Have a look at section 8, subsection 1FX. That's of the Personal Property Securities Act of 2009. And also it excludes from its operation a trust over an amount that's provided by way of financial accommodation. So have a look at section 8, 1FX. Also, so same provision. So what we're doing is we're saying that the trust retains its utility as a concept to secure priority where we're dealing with a remalpa clause or a trust a retention of title clause. And as we know, trust property is not available to satisfy the claims of creditors of an insolvent trustee. So using the remalpa clause and describing it in the context of a trust will mean that we don't even have that initial argument theoretically with a trustee, and we don't have to argue about whether it's a secured obligation or unsecured. It's not part of the trustee in bankruptcy's estate. So I guess what we're really looking at is if you're trying to retain priority, the best way to do it is to never lose control or ownership of it, which is the establishment of the trust. Alternatively, if you're going to be a creditor, you want to be a secured creditor, which is where the Personal Property Security Act comes into play. I guess what we're saying is that if you have a trust element built into the retention of title clause, then that will be good. And the courts will even infer the existence of a trust in those circumstances where they can. So if you want a case on this, have a look at Associated Alloys against, it's Associated Alloys Pty Ltd, against ACN 001 452 106, PTY Ltd in liquidation, was just a shelf company. The citation is 2000 202 CLR 588, and in that case the clause, the retention of title clause, specifically used the term in trust in favour of the vendor, and the High Court remarked that if the existence of the trust is explicit, then the absence of any express obligation to keep trust money separate does not deny the existence of the trust. So that Associated Allies decision establishes the basic principles where the parties themselves establish a trust in the contract for the benefit of the seller. It won't be a simple charge in favour of the seller. The court will not override the expectation of the parties in that regard. And they'll even look to surrounding circumstances to establish the existence of a trust, which is the ultimate, if you like, security from the circumstances. So it's a little obscure, but Ramalpa clauses are important in practice. Any questions about that? And you heard me say, pay attention to that. Yes, B?
Yes, especially obscure. So does the trust law have anything to do, what does it say in cases where the goods are mixed together or used to make something else?
That makes it a much more difficult situation, and the trusts law will help but won't necessarily provide all the benefits. But by establishing a trust as opposed to a security by way of a charge, what's the main advantage? Apart from the fact that you can argue with the trustees in bankruptcy and say, look, I'm not even arguing about whether it's I've got priority, it's my property because it's on trust. But apart from that, from an enforcement perspective, what's the big advantage of arguing that it's a trust rather than relying on the Personal Property Security Act? It's all to do with remedies.
I guess because...
Would you be competing with others for the balance of the cost, whereas if it's a trust, it's yours?
Exactly, yes. It's yours. You're not competing with other secured creditors or unsecured creditors. That's exactly right. That's the first thing. But let's say you still have an argument, as B said, what if it's mixed in other property? How do you deal with that situation? What remedies would you have in trust law that you wouldn't necessarily have in contract law? B's got it. That's the word I was looking for. What's that, sorry?
Yeah, sorry, that's what I was saying, John. Tracing.
Oh, you said that. Right, very good, Erin. Okay, so tracing. You've got a tracing remedy available to you if you can establish that the retention of title clause was in fact a trust obligation. Okay, so we got that. I mean, in an exam context, there's only so many words you can write about that in a short period of time. Let's talk about some other important things I want to talk about tonight as well. So let's talk about power to vary a trust deed. How do we vary the trust deed? Who has power to do that?
The trust deed may have something in there. If it doesn't, you can apply to the court.
Exactly. Perfect. Yep. So it may have something built in. If not, you can apply to court. So trustees often have power to amend a trust. If it's a discretionary trust, yep, beneficiaries by consent, says Brad. I agree with that. If it's a discretionary trust, there may be power to add beneficiaries, but you've got to be really careful about doing that because it might be deemed to be a resettlement of the trust, and that has all sorts of transfer duties and capital gains tax implications. But generally speaking...
John, are you touching on resettlement? Sorry.
Yes,
resettlement. I was just asking, are you going to be touching on resettlement?
Only incidentally. Was there a particular question, Erin, that you wanted to deal with?
No, I just found it a little bit confusing to try and get my head around it, that was all.
It is. Oh, look, it's a really touchy area, and that's where I'll go so far as to say you need to be really careful about doing things like adding beneficiaries, because if you do that, then it's probably going to be a resettlement or close to that, and that can have all sorts of financial obligations. You've got to be really careful when you do that. But leaving aside that general warning, trustees usually have power to amend the trust, but of course the trustee's obligation is to follow the terms of the trust. Now, as we speak tonight, I want you to think about a situation where the trustees, the settlors, have set up a trust in circumstances where their intentions are really good, but somehow things have gone off the rails and the trustees are now bound by the terms of the trust in circumstances where the people that set it up, all in good faith, are explaining that you can't follow through with the terms of the trust. And we need to highlight or think about how we can vary that trust, if we can, in circumstances where things have gone off the rails. I guess tonight, in saying that, I want you to take a special care and listen carefully. You can make of that what you will. So the trustee is obliged to follow the terms of the trust. We know that. But sometimes it's necessary to vary or amend the trust due to change in law or change in circumstances. So that variation might be an alteration or amendment, or it could be, as Erin pointed out, it could be a resettlement. So, and remember, and as Brad pointed out, we have beneficiaries of full capacity. They may decide to vary the trust as well. So the power may be built into the trust instrument, and the courts will look at it in such a way as to give it the most ample operation. So it means that there is a broad discretion given to trustees, and provided they're exercising their powers properly for the purpose for which it was conferred, the courts will generally try to support them. In other words, if they're exercising their powers bona fide, not for their own benefit, then the power to amend will be construed broadly. And now I think it was Linda who said the courts have the power to vary the trust, and it wasn't Linda. Might have been Erin, I'm not sure, sorry.
No, it was me, John.
Oh, thanks, Erin. Brad's got it, Section 94. That's where we're working towards. So you've got to know Section 94, and there's a case to have a look at in terms of the inherent jurisdiction of the courts, even before we get to Section 94, and that is Renew, N-E-W, 1901 to Chancery 534. Now, this will be in your text, I'm sure. So it doesn't authorise or sanction every act by trustees or even beneficiaries merely because it appears to be beneficial. It's limited to circumstances not foreseen or anticipated by the set law that causes the trustees to be unable to fulfil their duty to the trust. Now, these are really broad statements. What do we mean by something that's not foreseen, not anticipated by the set law, but creates a situation where the trustees are unable to fulfil their duty to the trust unless they make the change? So as a general proposition, have a look at Chapman and Chapman. That's the English position. Change in law says B, that's correct. And Chapman and Chapman, which is 1954 Appeal Court AC 29, has been accepted in Australia. And it does allow variations in circumstances that would tend to support the settlor's intentions and the parties' consent. Now that's all very well, but what if the parties don't consent? That's really where it becomes difficult. So Chapman and Chapman was supported in Australia. The authority for that is Tickle against Tickle, 1987, 10 New South Wales Law Reports at 51. Okay, so that brings us to Brad's statement about Section 94 of the Trusts Act, Queensland. So the court has jurisdiction to make orders to vary the trust, to vary the terms in circumstances where to do so would be expedient in the management or administration of any property vested in the trustees, or would be in the best interests of the persons or the majority of persons that are beneficially entitled under the trust, but is inexpedient or difficult or impractical to effect the disposition without the assistance of the court. So have a look at section 94 and for yourself break it down into those phrases so that it's almost becomes like a checklist to say this is when the court can act and these are the circumstances where it has power to do something. It goes on from that, but I won't go further. So let's have a look at some examples about how section 94 can be used in practice. The first is that it might be used to extend the vesting date of the trust. So the vesting day is the day that the trust officially ends, yes? So that means the trustee, upon vesting, is required to wind the trust up. But that may not be a suitable time to act. So have a look at a case of Arthur Brady Family Trust, Trekmore Trading Trust, that's Trekmore, 2014 QSC 244. And the court noted in that case that the section is not confined where the proposed transaction is expedient in the management or administration of any property. The court's jurisdiction, as is in the section, goes beyond that to deal with the transaction where it would be in the best interest of the persons or the majority of persons beneficially under the trust. So it's really the expediency in the administration or management or in the best interests. They're the main ones. So in that case, in Brady, the court was prepared to exercise its discretion pursuant to section 94 to amend the vesting date of the trust by extending to a date which was 80 years from the settlement date of the trust. And the result in that case was to amend the vesting date from 2017 until 2057. And the court said it has power to do that because of the intention of the creator of the trust, and that's a relevant consideration. But there are so many circumstances that one can think about. And a few months ago, I did sit and think about this, think about what would be a circumstance that could lead to thinking, to determining whether Section 94 applied or not. And I think some of the words make it very difficult to work out. And it's not always going to be consistent. So you'll recall the Reinhardt family litigation, and Gina Reinhardt applied to extend the vesting date of one of the family trusts, but the children who were the beneficiaries opposed it, and the court said no. It was very unpleasant, very expensive court action. Okay, so what is expedient? That's a really key word. What do we mean by expedient in these circumstances? Now, it's going to be flexible, quickly, says Brad. It'll be flexible. Fairly, yes. What happens if they adversely affect some of the beneficiaries? Then in those circumstances, there's difficulties. Have a look at Riddle against Riddle. It's an older case, but it's 1952, 85 CLR 202. And in that case, the court considered a proposed variation. And the court said that the expediency provision would not allow for variation that negatively alters the beneficial interests of some. And the variation which will alter the beneficial interest does not automatically mean that the court will refuse. And it talked about the main requirement being to vary the trust for the expedient management of the trust and not solely for the beneficial interests. Now, it's really hard to get a grasp on this, at least it was for me, and it is for me, continues to be, to the extent to which courts are willing to vary these trusts in circumstances where not everyone agrees and where someone will win and someone will lose. So the court in...
John, would it also have anything to do with trying to preserve the trust?
With what, sorry, Erin? With the what?
Oh, sorry. I was just wondering, will the court also consider such things as trying to preserve the trust, the intention of the trust?
Exactly, yes. And that's a really good point, because one of the equitable principles, of course, is that a trust equity will always want to preserve the trust and have the trust endure. So that is always a good fallback position, if you like. That's a good point. Okay, so in New South Wales, they call it an adjustment of the respective rights of beneficiaries. They say that the courts do have power to make those sorts of orders. Have a look at a Victorian decision of Royal Melbourne Hospital against Equity Trustees Limited. In that case, it's 2007 18 VR at 469, and the court had power to consider whether to give trustees a power to sell portions of a large estate by selling land to create a managed fund. There were issues about mounting taxes that had to be paid. And if the taxes weren't paid, the estate would be sold in portions by the government to meet the debts. And the grandchildren who were entitled to use the land were in favour of doing nothing. But by doing nothing, the property would be sold, nothing would be left for residue beneficiaries, which in that case were charities. And the court held that the submission of the minority grandchildren would deny the court the capacity to bring a sense of proportion to exercise of the expediency power. Now, we see this a lot when you're reading those sorts of cases, you're reading these commentaries. Just think about the inherent conflict between the interests of those who have an entitlement to property during their lifetime or someone's lifetime, as opposed to the interest of the residue beneficiaries, and we see that a lot in wills. And Brad says, had the children paid the taxes, would the issue have disappeared? I'm sure it would have. Yep. It seemed to me that the basis for that case was that we have to move to pay the tax, otherwise we lose the property, which denies the residue beneficiaries the. So if the taxes had been paid, I'm sure it would have been fine. No, it's a good point. So I guess it begs the question, how far will a court go to rewrite the terms of a trust? And courts will change the vesting date to avoid large capital gains. There's a decision of Stein against Sidemore Holdings, and of course, or to allow the trust to continue. And I mentioned before the Arthur Brady Family Trust case. Now, Section 94 is half the answer. The other half answer is Section 95, which excludes the requirement for expediency, which is what we've been primarily talking about. And it can be used as an alternative to an action pursuant to Section 94. So because in that section, it does require expediency. So Section 95 provides an ability for the court to make a change to the trust, make an order on behalf of various people, and there's a list of those people who may be the beneficiaries. As an example, have a look at the estate of Bradbury. It was 1999 QSC 145, and in that case the court refused to amend the terms of a trust to allow for a life tenant to receive the freehold because it was not satisfied that it was able to hear from all the potential beneficiaries, and therefore the consent of all relevant parties was not established to the court's satisfaction. And Brad said, did the case fall over? Yes, that one, the case fell over. So the court was not prepared to do that in those circumstances. The other...
Sorry, John, that was a pun on the Bradbury.
Ah, right.
Sorry, that was a pun on the
Stephen Bradbury. Yes, very good. And I'm sure you're all familiar with the Bradbury story. It's a great story. It's not a story of someone who was lucky. It was just someone who was very determined and kept going, kept his head down, won the gold medal in the ice skating. All right, the other one is, so thanks, Brad. Sorry I didn't pick up on that. Have a look at Perpetual Trustees of Victoria against Barnes. and that's 2012 for VR 385, and that was a trust about Ms. Barnes, who was born with autism. Under her father's will, she was entitled to income, and the problem with that case was that there just wasn't enough income to support her, and the court had to consider an application by the trustees to allow to draw on capital in order to cover the costs of caring for the daughter. And the Court of Appeal held that the power, which was the equivalent of Section 95, did not depend upon the consent of those that might otherwise have been beneficially entitled. I think in that case, in Barnes' decision, the court really had to work pretty hard to come up with a solution that meant that there was the income that Ms. Barnes needed because of her condition. All right, so that's our brief discussion on variation. Yes, Brad?
Can I ask a question in regards to problem 11.1?
Not that I can recall. I can't recall 11.1, but yep, let's...
Anyway, that's this week's tutorial question. And I read through it, and essentially the question whereby it's saying that at the end it says that the fund won't allow distribution or pension, under slab 3, all deeds had to be amended to include the payment of a pension. And I'm sort of concerned that if we've got a question like that in the exam, the SIS regulations would override what you have here in trusts to allow the courts or a trustee to make the necessary amendments that's asked for in the question.
Yeah, you won't need to worry.
So I'm hoping that we're not going to get a quick.
No, you won't need to worry. You won't need to worry about that for the exam.
Good, thanks. That's one less tube question I've got to do. I was sort of reading through and I was going, you can't do that, and you can't do that, and so I'm going, but hang on, there was one trustee, now there's another trustee. Well, how did that occur? There's a lot of material that was missing in the question.
I know,
to allow you to give advice.
I tried to steer clear of controversy in the exam questions.
Okay.
I'll put that down. All right.
Thank you.
Thank you. Okay, so we've talked about termination of trusts. Last week we talked about illegality, and from that you'll recall that we were talking about equity not coming to the assistance, generally speaking, of someone who has committed an act which is illegal. And this is just a refresher. We talked about bankruptcy. We talked about the presumption of insolvency to some degree. So have a look at Section 120 of the Bankruptcy Act, and you'll see some important provisions there. I'm not necessarily saying this is for the exam, but and we also talked about some family law provisions. So that's a pretty brief overview tonight, but that's effectively as far as I wanted to go this evening. And next week, I won't have much new material, but we can talk in more general terms about anything that's come up in the exam. I will just say something about the assignment. Overall, I was really happy with the assignment. You probably picked up on a pretty hard marker, but I was really happy with the way people attacked it. And one of my philosophies in setting examinations is I really don't like to be overly prescriptive in terms of an answer. And those of you that have worked with me in the past have probably heard me say on many occasions, there's not necessarily a right answer. You may have a completely different take on the answer to me, on the question to me. Even if you have the same take on the question, you may come to a completely different conclusion than I came to. And I was really pleased to see that people came up with a whole range of different options for the answers. I guess the standard answer, unsurprisingly, was In relation to the property, it's a resulting trust. If it's not a resulting trust, let's argue for a constructive trust. In relation to the cash, quis-closed trust, and if not, maybe a resulting trust. They were the standard answers, but we had a variety. Some people really strongly argued for the existence of an express trust in relation to both the property and the cash. Others brought in provisions in relation to Succession Act. Some people raised constructive trust as their primary argument, their main weapon, and argued resulting trust as an incidental. So lots of different ways you can attack it, but I guess that was the main one, resulting trust or quis-closed trust. The other thing I was really interested in is just to see how people would describe the remedies available to them. Because it's all very well to say, oh, look, let's treat this like a textbook question and we'll just write, resulting trust means this and this. I intentionally wanted it to be an outline of argument because, bear this in mind, an outline of argument is being presented to the judge, yes? So when you're preparing an outline of argument for real, be very careful about quoting law. Do so selectively. You may not quote any law. And the reason is that you're not there to educate in the sense of providing an essay question. You're there to argue on the facts. So the answers that I really liked were the ones that, okay, raise some law and a general proposition. Might quote Van der Velde, or you might quote Westdeutsch and Islington, or you might quote Calverley and Green. That's fine. Give me the general proposition. But then as quickly as you can, get into arguing about the facts. So I was really interested to know how people that were arguing for the plaintiff might deal with issues such as, why on earth would Mrs. T borrow all the money for the acquisition of the property when she controlled the amount? She was the one that went to the bank and said, this is how much I want to borrow. If indeed the $50,000 was intended to be money earmarked for the acquisition, then surely she would have asked the bank to lend her $50,000 less than she did. So I'm not saying there's right or wrong answer, but just to say that's the sort of thing the court's going to be interested in, rather than you necessarily putting in your outline of argument that this case was followed in New South Wales and then tell me about the circumstances of the case in New South Wales. The judge is going to say, I don't care about that, tell me about this case. So just bear that in mind for an outline of argument. Any questions? Yes, Brad?
Yeah, John. I was trying to, and because you lecture in evidence and you've touched on that with us in the past, as to what you're saying about, what the intention was of that 50,000, and I'd consider, in my answer, I'd considered quick close, but I sort of was more concerned then of the remedy and then the court's ability to recover if they considered an illegality on the $20,000 first homeowners grant. So my position was on the evidence. I felt that it was an illegal transaction of the parties. What I'm wondering is, to do a submission in the future, in examination or cross-examination, how much, should you touch on it in your submission to then seek to open the door to then examine during the trial?
Yeah, no, absolutely.
Or once your submission, that's
look, just bear in mind, of course,
because there was a few key points lacking.
In this case, the trial had already been concluded, so it was an outline of argument in relation to the final result. So it wasn't meant to be a tool that you then use in the trial in that sense. And of course, you've got to temper my comments about you may not even put much law or any law in an outline of argument, because if you, in a university context, you've got to be careful. And the way I tried to describe it was, look, put as much law as you like in the footnotes, but leave the outline of argument as pure and as practical as you can make it, was kind of my intent behind it.
Okay.
I hope that provides some response. Yes, thanks, Brad. Any other questions or comments?
Sorry, you said that the 50,000 was a resulting, you could argue alternatively as a resulting trust. I actually thought resulting trust was only with regards to, is it property? That means it can be any kind of property, not just land property.
It can be real or personal property for a resulting for a presumed resulting trust. It doesn't have to be just real property. But my personal view is that wasn't the strongest argument that you could make. That it was more a quist-closed argument. But I did forgot to mention Brad's point about the illegality, and I think that was a very important point. And some people like Brad sort of really stressed that aspect of it as well. Can I just say, as a general rule, I would say 90% of you went for the plaintiff. When I wrote it, I said I would go for the defendant any day on this one. It's probably a harder argument on the face of it, but I think you can really shoot more holes in it. So when you were writing for the plaintiff, overwhelmingly people wrote in terms of the positives for them, but there weren't too many statements about how do I deal with the negative issues that the other side are likely to throw at me and deal with those hand grenade issues. The estate had no money to pay, says Brad. So just bear that in mind as well, that when you're writing those submissions, you've got to be aware to defend probably is more than you are attacking as a general philosophy. But I hope you enjoyed that exercise. I enjoyed reading the answers. It was a long slog getting through 100 of them, but it was good. I was really happy with the work. Actually, really happy with this. The presentation was superb. Overall, people are really presenting their work in a professional manner. And I always say at university, in Introduction to Law, things like if you're charging $400 an hour, it's got to look the part. And people are really doing that. I was really happy with the presentation overall. It was great. Okay.
So the greater the presentation, the more you can charge, John?
No, I won't say that. But what I will say is the easier it is to justify your charge if it looks the part.
Worry about the remedies. Is that all? You just stop at constructive trust? Because I tried, because there are some people who are arguing for specific performance, and I said, no, you couldn't because you didn't have a contract. I don't, what else?
No, I don't think specific performance was an available remedy. But in terms of remedies, and I'm glad you raised that, I meant to say it be, I think the most obvious remedy to my mind was a declaration. And be specific, say, even if you start your outline by saying, respectfully, the orders that I seek are 1, 2, 3, 4, because what you want to do is hear the court say, the orders that I make are 1, 2, 3, 4, and just quote your words. That's what you really want to hear. So make it easy for the court to decide things your way by saying, this is exactly the order that I seek. And I think the order that you seek is a declaration to the effect that there is the existence of a resulting trust in relation to the property, or a declaration in relation to the existence of a quis-closed trust. But then follow it up, I think, and say that you seek a mandatory injunction to compel the transfer of the property from A and B to, or B and B to T. So they're probably the standard remedies that I would have gone for: declaration and mandatory injunction. But other remedies,
so John,
yes.
So John, what was your advice if you argued on behalf of the defendants? I just said the court should strike it out, both.
Yeah, I think I did like what you said, Erin. And I just can't remember all the individual papers, but I think, as I said, one thing that I really didn't see a lot of for those that were arguing for the plaintiff is an explanation, or a possible explanation, as to why Mrs. T went and borrowed all the money. Can anyone think of an argument now why she would do that, and how you would use, having now been faced with that argument against you, how do you counter it?
I think that's why I found it easier to take on the defendant's side, because she hadn't really provided a good reason for borrowing the whole amount after she'd given the sister the $50,000 6 months prior to that.
Mm-hmm. So what would be an argument now that you could advance?
she borrowed against her other property, just to have it in a one lump sum.
All right. So a possible scenario is it was more convenient for her to borrow all of the money.
Yeah.
With the expectation of having the 50,000 returned to her. Yep, that's a possible scenario. Any other scenarios or any other arguments you could use?
Yeah, because she would get more cash. She'll get more liquidity. Because if she borrowed less money, she wouldn't have that extra 50,000 to use to, say, buy shares or do something else with it.
Okay. Yep. So a liquidity issue. Thank you. And Tamara, what did you have in mind?
I was just going to say, I kind of felt that the sister, Mrs. B, or whoever it was, like sort of years ago, Mrs. T said to her, I'd really like to buy a property for you one day. So it's almost as if she held on to that. And sort of now she's saying, Mrs. B, I'm financially insecure and, I'm on poverty and I'm this and, I'm so hard done by. And it's almost as if the pressure was on Mrs. T to give Mrs. B what she wanted, basically.
Yes, so succumbing to the pressure. Yep. Vivian, did you have a theory?
Can you hear me?
Yes. Yes, Vivian.
Yes. Okay. I basically thought, well, maybe they started looking at a property at, say, 200,000, thinking that a $50,000 deposit would be great, and then they turned around and went and bought something that was 1.2 million, which $50,000 would be insufficient as a deposit. So that was just an idea that came out of the blue.
Yep. Okay. So they're good thoughts. Any other thoughts?
Well, she did go to a financial advisor.
Yes.
And possibly they may have, because obviously Mrs. B had nothing, so she might have been getting rent assist, and they tried to structure some arrangement where she could get some gearing aspects on the funds.
Yeah, and look, I think these are all really good hypotheses.
Not that I believe she could. Not that I believe she could, but you went to a financial advisor, that's enough said.
So I think what you could do if you're acting for the plaintiff, trying to anticipate and negative that argument that Erin's going to throw, was it Erin who's throwing these arguments on behalf of the defendant, is to say that's all very well and these things may have happened. It may have been a number of things that occurred between the date of the providing of the $50,000 and the ultimate settlement of the transaction. But in a way, all of that's irrelevant because what we're really looking to do is determine the intention of of Mrs. T at the time. So the events that occurred afterwards may give some indication as to her thinking at the time, but it's not conclusive. And it might just be as simple as she changed her mind in borrowing the money at the end of the day, but that doesn't change what her intention was at the time that she created what we call as a resulting trust. So maybe that's an argument.
John, do you consider there's an element of unconscionability and whereby the son and daughter benefit from the generosity to the mother from her sister? So unfortunately, Mrs. T died, and obviously one of my defendants I had the estate of because it didn't really say whether the estate had settled or completed administration. But I just felt that the son and the daughter knew that the auntie had borrowed the money, yet they're thinking they can take the property clear of any debt obligation.
Yep, you could argue unconscionability. I think, was it B, did you argue for the unjust enrichment?
Well, I did argue that they would have a windfall equity, but coming back to that mandatory injunction to transfer the property, I think it's the injunction to transfer the property, but it had to reflect, not transfer the whole property, but to reflect their contributions because of the homeowner's grant. So
yes.
Not just, and I thought that the court wouldn't grant an injunction if compensation would do. I thought that was one of the things about injunctions, was that if we can compensate you, because if this lady, she doesn't actually want the property, she just wants to repay her loan. So she actually wants the money more than the property.
That's a very persuasive argument, and I think you're right. So an equitable compensation, equitable damages in lieu of the injunction. Yep, noting the contributions and dealing with the proportionality issue as well. No, some good thoughts there. Okay, well, look, sorry about the late
John,
start.
can I just throw,
Yes, sir.
I just want to throw something in from my life. When my mum passed away, she left a property to myself and a brother, and the elder sister put in a family provision application. Anyway, it went through mediation, and because my sister, who was the only executor, another sister, she was left cash. But by the time it all went through mediation, all the squabbling, there was nothing left of the cash.
Erin, I'll just stop you there. Just remember, of course, this is all going live.
Yeah. But basically my question is, because my sister missed out on, say, $10,000, let's say it was $10,000, I said, well, when I get my settlement, I will give you $10,000. So that made me think, well, hang on a minute, have I just given her a gift, or can I claim this as a trust?
Oh, I'm not sure I better go there with that one. All right, look, I'm running over time. Thanks very much for your patience. Next week will be just an overall review. So if you have any questions, get them ready to go. We'll see you then. Bye.